There is another hearing after us at 3 o'clock, which is why I'm trying to start as quick as I can, because we'll have a hard stop right before 3 o'clock. There are two bills on the agenda. There's a sign-up sheet down the end here. If you want to be heard, please sign up. I'm going to ask Senator Rhett if he'll please open us up with a word of prayer.
Thank you, Number 8. Thank you, Mr. Chairman. Bow our heads. Oh, Lord, it's another day's journey, and we're glad about it because we have another opportunity to do the people's work. Give us your wisdom, touch us from head to toe, anoint us so that we can do the best we can for the best people in the United States, in the state of Georgia. We ask this through Christ our Lord. Amen.
Amen. Thank you, Senator. We have one guest judge with us today, Superior Court Judge Burt Guy from the Brunswick Circuit. Stand up, Burt. Welcome to our committee. Yeah, thank you for being here. You're always subject to being called up here and asked questions, so be ready in case something comes up. We're going to start with Senate Bill 316, Senator Anna Vitarte. If you will please come up. And you're working off a substitute. If you can please tell us when you start the LC number of the bill you're working off of. Make sure everybody has that in front of them.
Yes, Mr. Chairman.
No, it's not. It's about to be. There you
The sub I have in front of me is LC 490783S.
go. All right. If you'll please tell us about your bill.
Okay. Senate Bill 316 is a bill that addresses cyberbullying, adult cyberbullying students, minors, and also creates a situation for local boards of education to notify parents and students that bullying and cyberbullying can constitute stalking. Currently, under Georgia law, an individual convicted of stalking is generally punished as a misdemeanor. Upon a second and all subsequent convictions, however, the defendant is guilty of a felony and will be punished by imprisonment for not less than 1 year and not more than 10 years. This bill provides that in addition to the above, a person 18 years or older who commits the offense of stalking against a minor is guilty of a high and aggravated misdemeanor, fined not less than $1,000 and not more than $5,000, or be imprisoned for not more than 12 months, fined or imprisoned. This bill came to me, or this idea came to me from a student, a dual enrollment student from North Paulding High School. That student's here today to testify to this bill and kind of the why and the need of, we believe that we should update the law in this regard. Also, the acting district attorney for the Paulding Judicial Circuit is here to testify, and I think potentially somebody from the Paulding County Sheriff's Department. Thank you, Mr. Chairman.
Any questions for Senator Anna Vitarte about his bill? You have no questions at this time.
That's a first.
That is. We have others that have signed up to be heard on the bill. You mentioned a student advisor. I'm assuming that is Mr. Cooper. Is it Guyon? Am I saying your Guyon? I was close. Come on up, Mr. Guyon. Good afternoon.
Good afternoon.
Welcome to the Senate Judiciary Committee.
Thank you, Mr. Chairman, and to the members of this committee for allowing me to come speak today. Well, today I'm speaking in support of Senate Bill 316. More importantly, I'm coming to raise concern on an issue that's impacting a generation: cyberbullying. We live in a world with not only information at our fingertips, but instant communication with anyone across the globe. While so many benefits have come out of this, it's important to note the unique issues that have also arisen from the internet and social media. Individuals who prowl about the darkest corners of society and prey on those who are the most vulnerable, our children, have been given a platform to stand on and a keyboard to hide behind. They target our children and harass them verbally, stalk them, and even threaten them. In today's world, where there's already so much added pressure on our youth, whether it be school, family life, or depression, no student should have to add an adult harassing them to the list of problems that they're dealing with. Those individuals should be adequately punished under the law in order to protect our children. Senate Bill 316 does that. While holding adults accountable is important, that situation is less common than a kid harassing another kid online. The most impactful part of the bill reads as this: each school board shall be required to adopt a policy that prohibits bullying of another student prohibits bullying of a student by another student. The bill also lays out a clear process of reporting, reviewing, and disciplining those who have harassed, intimidated, and cyberbullied another child. Too often, situations get pushed aside, ignored, and overlooked by teachers and administration. This can often lead to the escalation of the situation and could also end with a child taking their own life. Teen suicide increased 26% in 2021, and much of that is directly related to bullying and cyberbullying. 11 out of every 100,000 students took their own life last year. As public servants, you have a job to do until that number is down to zero. As Senator Jason Vitarte's student advisor, I felt that there had to be some kind of legislation that we could come up with that would make a positive impact on students across our great state. After talking with my peers and bouncing ideas off the senator, we came up with Senate Bill 316. We see so often partisan and divisive legislation come through this Capitol and even this committee. And I'm proud to say that this is a bipartisan step in the right direction that doesn't solve the problem, but it helps us get there, because it is really a huge problem that we face, and this is how we best felt that it was dealt with. This holds the bullies accountable and the cowards that hide behind screens, and it puts our youth first and our students first. Again, I'd like to thank each and every one of you for your time and willingness to hear such an important issue. I would like to thank Chairman Strickland for his support of this bill, and for the senator for being a voice for Georgia students in introducing this bill. Thank you guys so much for the opportunity to speak today.
Thank you. And you are a student where right now?
North Paulding High School. I'm a dual enrollment, actually, with Kennesaw State, but a senior at North Paulding High School.
Senior. Well, thank you for, at such a young age, being so involved and making such a difference with legislation like this. Do you live in Senator Ann Vitarte's district as well?
Yes, sir. Just down the road from him. Yeah.
You better watch out.
He reminds me every day, Mr. Chairman.
No, seriously, it's and I agree with you. The part that is probably the best about the bill, other than adding the aggravation of the misdemeanor here, but the part about having local boards of ed educate students about this and let them know that there are real threats that can come criminally to you if you do bully someone else or stalk someone else at school.
Yes, sir.
So I appreciate your work.
Yeah.
Any questions from the committee? All right, they're quiet still so far today.
Lively crowd. Huh?
I know. Thank you. All right, next we have Mr. Matthew Rollins.
Mr. Chairman, committee members, thank you. I'm not a fan of having to follow Cooper.
Yeah.
He speaks more eloquently than I can, and he's a high school student. He's going to take my job after his. Committee members, I am here to testify in support of Senator Ann Vitarte's bill, and I'll be very brief with this. Is we've seen, I know that there are a number of younger individuals in the room, but when we were growing up, we weren't online. We weren't on social media. We didn't even have cell phones. I got a pager when I was in high school one time. But we didn't have the issues that our youth are facing today. A massive portion of their lives are online, and they are subject to the bullying. They are subject to intimidation by many different groups, and they should never be subject to that from an adult. What I would also point out, and it's interesting because we have a number of gang experts that are in the room now, but they can tell you that social media is utilized by criminal street gangs. the criminal street gangs, through intimidation, are how they dominate an area. They're how they recruit new members. And this goes to address part of that issue, which is criminal street gangs using their intimidation, using social media, using stalking tactics to create new members and grow their influence in a community or in a high school. I applaud Senator Ann Vittardi for introducing this bill, and I would ask that everyone support it. And I'll answer any questions you might have.
Mr. Rollins, I have one question
Yes,
for
sir.
you. When you look at taking a misdemeanor to a high and aggravated misdemeanor,
Yes.
other than the fine itself, is there anywhere else in the law where the punishment is any different from any other misdemeanor?
The punishment range is still going to be the same as a misdemeanor, Mr. Chairman. However, the courts, the judges, the prosecutors, and the defendant are all treat that case differently. We're not, from a reality standpoint, they're not going to prison. We're not talking about sending somebody to prison for 10 years. That's not available. But we are looking at that case as being more serious than your average misdemeanor case, and is typically treated by a judge and by prosecutors that way.
Okay, we have a question from the committee. Senator Calzert.
Thank you, Mr. Chairman. Following up on that, I don't know if this is an element of state law or just the way they handle this in Athens, Georgia, but high and aggravated misdemeanors in Athens, they're required to serve 80% of the sentence. They don't get day off for good, time served or that type of thing. So it can significantly lengthen the amount of incarceration. Is that an element of state law that is applied the same everywhere?
It's actually determined by each county, the sheriff or custodian for the jail in each county, because all of those sentences would be served in the county jail or the county detention center. That the local custodian is the one that determines the credit time that is given. So if they want good behavior time or 2-for-1, that's determined by that individual custodian. And evidently, the custodian in Athens has chosen 80%.
Okay. And just one follow-up is that, so what you're doing is making penalties harsher if you cyber stalk or otherwise stalk a teenager
Yes, sir.
than you would if the kid was in college, or if it's a senior in high school that's already turned 18. It's almost back to hate crimes. We're having different penalties for the same conduct based on the category of the victim.
Yes, the age of the victim is a factor, and I think it's an important factor. We recognize age throughout our criminal statutes in Georgia, as those juveniles are more susceptible to being victimized by adults. And so additional protections have to be put in place to protect children.
But this does not heighten the penalties if it's another high school student that's under 18 doing the stalking, and isn't that pretty much who's doing the bullying as their classmates? I mean, this doesn't even address, it's like older people picking on high school kids you address here instead of other high schoolers that are the ones more likely to be, cyberbullying.
And the statute as is, Senator, the statute as is, it still would apply in those situations. Another student committing the act of stalking on a fellow student is still a criminal act. This is simply saying if it is an adult doing it to a child, we are going to increase that punishment accordingly, based upon that aggravating nature of that fact.
Thank you.
I will point out one thing that Senate research pointed out to me is OCGA 17-10-4 does define punishment for misdemeanors of a high and aggravated nature, and that includes the requirement that a person sentenced for a misdemeanor of a high and aggravated nature may earn no more than 4 days per month earned time allowance. Do you know what that means?
So good time credit is commonly the term utilized. So if somebody does not have, if they're an inmate in the detention center, they don't have any disciplinary actions taken against them, they can be given credit to
Right.
them. This limits that. So I apologize. I thank you for pointing that out. I didn't recognize
So I guess that would be the other place other than the fine itself, where there is a difference in the punishment, at least by code.
Yes, sir. There is. Most aren't giving that much time. I guess it depends on your jail population and your individual jurisdiction, but most don't give that kind of time as it is.
Okay. Senator Rhett?
Thank you, Mr. Chairman. Just following up on Senator Cowsard's questionings, I just want to know, are the sentencing guidelines, are they mandatory, or if it's up to a judge's discretion following a guideline? Because you know how young people, they'll do silly things, and just taking that into consideration.
Yes, Senator, ultimately, the total sentence time it hasn't changed. It's still 12 months. We are talking about credit time and that kind of stuff, which is ultimately determined by the custodian. But the sentencing range up to 12 months is still within the discretion of the judge, just as it would be with a standard misdemeanor. There is still discretion allowed by the judge in the sentencing.
Any other questions for Mr. Rollins? All right, thank you.
Thank you.
Next, we have Sergeant Mitchell. Not here. What about John Floyd?
I'm here to comment on a different bill. I'm sorry.
Okay.
On the wrong list. Apologize.
All right, there's Senator Anvatarte. You want to come back up? Senator Kirkpatrick said, "Where's he going?" And she pushed her button.
Oh, sorry. I apologize.
Additional
Senator.
questions for the author?
A simple question,
Yes,
Mr.
ma'am.
Chair, which is, was there anything, what was different with the sub from the original bill?
Senator, I'm gonna let the chairman speak to that because I think there was a little bit of wordsmithing based on recommendation from legislative council in terms of that piece of it.
Yeah, we had it in the original bill. It was not still a misdemeanor. The jail time went all the way to, I think it was 1 year is what it said. And so it made it a felony instead on the sentencing side. And so to get back to high and aggravated misdemeanor was a tweak in the language there that would still make it, as far as jail time, have the same imprisonment of less than a year. Did I say that correctly? Okay,
Thank you.
thank you. Any other questions for the author of the bill? All right, what's the pleasure of the committee?
Motion to pass.
We have a motion to pass by Senator Kennedy. That is Senate Bill 316 by LC 490783S. Do I? Okay, I will, let me see if we have a second, and then I will call you up, because you're right, you signed the other one, I see you wrote 316, that's my fault. And so is there a second for the motion?
Second.
There's a second. And if there's no objection, I'm going to call her back up and let her be heard on the bill. Ms. Maisie Lynn Girton.
Thank you.
And you did sign up, it's just you signed the other one, but I see you wrote 316, so I'm sorry.
Sign-ups today. Sorry about
That's
that.
okay, make sure you pull that mic up.
Yes.
Use,
Yes, this
sit in
one?
that chair, yeah, we have an issue with that. There you go.
Okay. Now, so we, the concerns that were addressed in the sub are many of our concerns. We would just commend to you a couple of points regarding line 48, which is actually not yet changed in the bill, and line 49. Typically, when we're talking about sentencing, it occurs after someone's been convicted of an offense. And in this statute, for some reason, it contemplates commission of the crime. So you can look even down on line 53 and talks about a second conviction or subsequent convictions. So it's just while we're in the code section, if the committee would want to make that adjustment, I'm sure legislative council would have the most appropriate language there. But then in addition, we would, as the chairman mentioned, there is a sentencing scheme already set up in 1710-4 for higher and aggravated misdemeanors, which, unlike this particular bill, does not mandate a minimum fine. Here, there is a mandated $1,000 fine. Typically, for a high and aggravated misdemeanor, it's up to $5,000, which is what we, of course, would prefer to see. It just track with the sentencing scheme that's already in place for these types of misdemeanors. I do appreciate Senator Cowsert raising the issue of the conversation around this bill is about interactions between children, and that's certainly not what the language of the bill does. So it's obviously a policy matter for you all to consider if this is really the policy that addresses the concern here or not. I know that there are 18-year-olds that are in high school. I was not one of them. I was here and in college by then. So I know that it can happen in this way, but it's probably not the most targeted and precise way to address the real harm that the people that are here concerned about it want to see addressed. And that's really all we have to offer today. Thank you so much for letting me.
Any questions for Ms. Girton?
Sorry.
All right, thank you. I apologize for missing you. Sergeant Mitchell that signed up to speak just arrived as well. You want to step up? How are you?
Doing well, sir. How are you?
Good. We have a motion due pass and a second on the floor, but you did sign up to speak. I know you traveled to come here, so I'll give you the floor.
Indeed, I appreciate that greatly. My name is Rodney Mitchell. I'm a sergeant with Paulding County Sheriff's Office. I work in the juvenile division, and I'm also one of the Internet Crimes Against Children investigators. When we're dealing with cyberbullying, it's a situation where we have to address it in so many drastically different ways because there's no specific instance of cyberbullying. Number one, we have to make sure that when people come to us that it's not just somebody that has been mean to them or has even attacked them verbally or orally over the internet, but that it's a repeated behavior. Secondly, we want to make sure, as it relates with juveniles, that I have a lot of history dealing with, that if it is a situation where it's an adult that is the one that is harassing or cyberbullying a juvenile, that is dealt with in a much different fashion than it would be as if it were two juveniles dealing with each other. On top of that, if it is two juveniles dealing with each other, it goes from the cyberbullying into the physical world of bullying very, very quickly, because with a lot of these juveniles, those two things are intermingled. Because a TikTok video today is a face-to-face encounter tomorrow, whether or not they're in the same school or even the same school system, because they have much more access to vehicles and going to meet each other and taking care of things, and it escalates the situation much, much quicker. My understanding of what is being presented is to make sure that the juveniles are more protected from the adults that are going after them, on a first offense, but also making sure that they're taken care of much more severely on second and subsequent offenses after that. Secondarily, I believe I read in the piece to make sure that school systems are also made aware to focus on educating these kids. I think a lot of these types of issues really comes back to education, and as we educate them on what are the elements of separate individual crimes that are all rolled into this term we call bullying, or this term that we call cyberbullying, it's also harassment and harassing communications. It's also stalking. The first time I explained to an individual that they were being arrested for the charge of stalking when they had no idea. And so once we were able to convey that, all of a sudden people started taking that a little bit more seriously. And I think that education component through school systems and discipline tribunals is a huge piece as well.
All right, thank you, Sergeant Mitchell. Do we have any questions from the committee for him? All right, thank you for coming to share with us.
Appreciate it.
All right, the posture of the bill is there is a motion to pass by committee substitute and a second. Is there any amendments? Any discussion on the motion? Senator Cowsert.
Thank you, Mr. Chairman. I just wanted to let the author know and the folks here, I'm going to vote against this bill. And there are a variety of reasons. One is that I spent about 4 years of my life serving on Governor Deal's Criminal Justice Reform Committee, where he pretty much the signature initiative of his administration, who got a building named after him, was to revise all of the criminal code and assess the appropriate penalties for different levels of conduct. And then I've watched the last 4 years us piecemeal undo everything that we did over an 8-year period. By every bill just simply tries to say, I don't like that conduct, so let's increase the penalties. Well, we're getting right back to putting everybody locking people up for things that are not that significant. This one bothers me because it's aimed at teenagers. And I don't know the rules on expungement or restriction of records if it's high and aggravated, but I think it's more difficult to get these off your record. And the definition of stalking, nobody really talked about other than the cyberbullying. It's really anything. If you follow somebody, you put them under surveillance, you show up at places without their consent, any really kind of minor behavior if it's deemed to be an intent to harass or intimidate them. And I can just only imagine all the high school kids that go through a breakup where somebody, is the jilted lover that wants to, to please take me back or whatever. And it's very easily defined as stalking. And now if you're a teenager doing it, people that are least mature and don't know better, now you're high and aggravated and you're spending 26 out of the 30-day sentence in jail, and now you're being asked to pay a minimum fine of $1,000 that can't be waived, and it can be up to $5,000. I get it that the conduct is not appropriate, but it concerns me that we are sort of piling on a bill that's targeted just for young people. And I don't know what happens if a 13-year-old bullies a 14-year-old, but I think the definition of this is they now have a high and aggravated misdemeanor. And I think it should be more egregious conduct before you're locking people up, where the judge has no discretion to waive that sentence, and the law is requiring us to give them no more than 4 days a month. I've seen it too often where things that are not that intentionally threatening somebody physical harm can be deemed to be stalking, and I just feel like there's some difficulty here. I love the part about having these school boards educate their children that this type of conduct that they may not deem to be stalking, when you follow somebody in the hallway to say, why won't you go out with me Friday night, and they don't want you to do it, is a high and aggravated misdemeanor. So for those reasons, I'll be voting no.
Thank you, Senator Cowsert. Any further discussion on the bill or the motion? Are all those in favor of the motion to pass by committee substitute, please raise your hand. 7. All opposed? 1. Motion carries. Thank you. Next bill we have on the agenda is Senate Bill 359, Senator Albers. If you will tell us which LC we're working off of. We also have a substitute for this bill too, I believe.
We do, Mr. Chairman.
Now you're live.
Okay. I've got substitute Senate Bill 359, LC 490788S, and I'm bringing up some backup if that so pleases you, Mr. Chairman. I've got Mr. Mike Carlson here, who works at the Fulton DA's office. He's the executive DA for the Major Crimes Division. And I'll begin when you are ready.
All right, go ahead.
Great. Let me give a very brief background. Beginning this late summer through the fall, a Public Safety Committee met on numerous occasions to address the rising crime problem we're seeing throughout the state of Georgia. We see the headlines oftentimes here in Atlanta and Fulton County, but we know this is happening in other places as well. We had a series of meetings, and we brought in what we believe to be all the proper stakeholders. And they were from all of our state police, GBI, Department of Corrections. We brought in local chiefs of police as well as sheriff's organizations. We brought in judges, district attorneys, prosecutors, solicitors, you name it. We brought them in front of that committee and got a windfall of feedback. Worked very close with the governor's office as well and the lieutenant governor to distill this bill, which is the Safe and Secure Georgia Act, really an omnibus crime bill, if you will, to address many of the issues that we think are going to ultimately improve safety. I want to commend what actually Senator Cowsert said earlier. The theme of this bill also was to make sure that the good work that was done under both Governor Deal and with Governor Kemp with criminal justice reform was still at the heart of this. But at the same part, we also have convicted violent felons who are rotating through our system and ultimately causing great harm to our families. So I'm going to take you at a high level through the bill, and then we can dig into the details. I'll go section by section. Really beginning on Section 2. Our accountability courts have been a great addition to the state of Georgia. If you have not been to an accountability court graduation, I would encourage you to, and see if you can make it out of there without having some wet eyes. It's just fantastic. But we do have some of our friends in the judiciary whom I love very much, who not only want to be judges, they want to be social workers and legislators. And sometimes folks that should be going to superior court are going to an accountability court. As an example, if you hold someone up at gunpoint and steal from them, and oh, by the way, you also had drugs on you, does not send you to the drug accountability court, although we have many examples where those type of things have happened. So in the spirit of keeping what was there before, the first section of this bill, Section 2, has the accountability courts to provide information back for oversight, simply sending their reports back to the normal legislative leaders we had before, the Speaker of the House, the Lieutenant Governor, these committees as we are at today, to provide oversight to make sure we're just doing the right things. Again, we don't want to diminish it, but we also want to make sure there's proper oversight. The next is Section 3 of the bill. This is possession of firearms by convicted felons. These are folks who have had previous convictions for violent felony offenses. Now, I want to be clear here. This is not remember the old adage we used to talk about a lot, which was, let's make sure we're putting away the people who we are afraid of as opposed to people we're mad at? These are the people we're afraid of. And in this case, those that have subsequent problems, they're going to have to serve a mandatory 5-year sentence, because these are violent felons who are continuing to do things that are putting people at risk and at harm. And candidly, if you look at some of the major problems we're seeing, it's the same type of violent offenders time and time again. The next is Section 4. This has to do with our civil or issues for gangs. Today, if they go through a criminal trial, it's tied together. They can use all that information that happened in the criminal trial, no matter whether they pleaded guilty, NOLO, or something else, and they can pull that into the civil trial. Make no mistake, the single biggest problem we have with crime in our state of Georgia is gang violence, and there's nobody close in second. Okay, next is in Section 5. This is a multi-county venue provision. As we know, criminals don't usually stop at the county line. But today, if they've moved around to a couple different counties, we then have each one of the counties try to do that individually based on where they were, if they drove across, if they committed another crime. This is be able to pull that together so we can go after the bad actors in the first venue. Section 6. This is really to target repeat offenders again. And for this, I'm going to just flip to my next page here. This allows us to really focus on. I've lost my place here. My apologies here. My apologies. So in Section 6, oftentimes we do not connect the dots when people cause harm, especially to our elder abuse, child, special needs, and our most vulnerable population. What happens is these folks have been arrested many, many, many times. But when it comes time to they get in court, they're only talking about the very one issue they just had. So we take someone who is a repeat offender who's had nothing but problems, and we slap them on the hand and we send them back out to do the same thing over again. This allows us to tie all those together to make sure that those repeat offenders, again, are the ones we're going after. Section 7. This is for creating more opportunities for pretrial resolution. I think we all know how backed up the courts have been since COVID began. And that, while it's starting to catch up, it's going to take years in some cases to catch up. We also know that pretrial resolution can be a very effective way for us to catch up, as well as make sure that all the parties interested have a resolution that is satisfactory. This allows us to create many more ways to do that, and I will talk about that in significant detail when we get through the line item of the bill. Next is Section 8. This is the, again, getting back to the area where we have defendants and their prior bad acts, to make sure that we are connecting the two of those together and we're not allowing them to slide. Section 9 is codifying our video hearings. I think we all know that during the pandemic, during the governor's emergency order, that we've been doing video hearings regularly. This, first off, is probably the single best thing, as they say, never let a good crisis go to waste, that has come out of COVID. We are able now to do video hearings that, first off, help those folks that have been arrested to get quicker access, but also it's wonderful for our corrections folks as well as local sheriffs and jails not to be moving people around. This has really been a great improvement, and I think if you talk to anybody, and I know there'll be folks here to testify today or in your next meeting, Mr. Chairman, if we run out of time, that will agree that this was a great move and we need to codify this for the long term. And then last, but certainly not least, in Section 10, this allows for concurrent jurisdiction for the GBI, so they can be involved with cyber, domestic, biological, chemical, and nuclear terrorism, and elections. As you all know, the GBI is a support organization. They have to be called in. This will allow them in those areas where they have the proper experience to be there. I want to thank the sheriffs. We actually scaled this bill down, so what you see in this committee substitute committee members and chairman is a change in order to address some of their concerns and needs. I know that's a lot, and I know it's a big bill. So I will take a pause and see if there are any questions, and then I'll ask Mike to help me if we need to go section by section.
I had a question on Section 7. This might be a Mike question, because it's looking at the rules of evidence for criminal and civil matters. Help me understand lines 184 through 186, which situations we're dealing with. Is that a change from the current law? Because we have a situation where there's no objection made to evidence coming in, it sounds like. There's no ruling, and so I don't quite get the situation we're after there.
Senator, could you please direct me to what line?
Use the other mic.
Oh.
It's
All right,
lines
thank you.
184 through 186.
Yes, Senator, and the purpose of the recommended revisions to Rule 103 was to clarify responsibilities pre-trial and at trial for filing motion in limine and making objections. And what was done was every Rule 103 from across the country was researched in order to attempt to get the best possible language from other jurisdictions in there. So what 3 does is reinforces the existing law on that and makes it a matter of statute with more clarity that when there is not a ruling on the record concerning the admission, then an objection must be made to preserve that claim of error on appeal.
Okay.
We would still have the plain error standard that remains in 103 as it currently stands, where there wouldn't be an objection. But that, again, is also designed to encourage a pretrial addressing and hopefully resolution of critical evidentiary issues.
Okay. Thank you. We have a question from Senator Jones.
Thank you, Mr. Chair. Just a couple questions. Number one is on Section 2. What can you kind of like go into what maybe is going on with the accountability courts? Do they not have some type of oversight now, or what's taking place?
Thank you, Senator. As mentioned earlier, you know, a lot of them are fantastic, and again, a lot of our judges, or most of our judges, are doing exactly what they're required to do. However, we do have some that are putting people in accountability courts that have charges that should not be there. So this is putting some oversight into place that does not exist today, really to come back to us as the legislature. And again, I use my example of someone who committed armed robbery and held you up at gunpoint and also had cocaine on him. They don't go to a drug accountability court for cocaine if they held you up. But sometimes that is happening today, unfortunately.
Okay. All right. Thank you, Mr. Chair.
Any other questions for the author? All right. Thank you.
Thank you.
Okay. Mr. Floyd, John Floyd,
It's been covered, sir. Thank you.
are you sure? Okay, all right. All right, we have Thomas Weaver. Good afternoon.
Good afternoon, Mr. Chairman. Mr. Chairman, members of the Senate Judiciary Committee. Let me start by saying that Chairman Albers has been better than good to me as a member of my legislative delegation and also as a good friend. However, I have to share in earnest a sincere concern that I have that makes me oppose the bill, and it's vested entirely under Section 3 of the bill regarding the amendments or the proposed amendments to the crime of possession of a firearm by a convicted felon. And perhaps it might come as a surprise to any of you, well, what could he complain of here on this? It's just strengthening a penalty for those whom have previously been convicted of felony domestic violence. And while it's true that that's what the measure proposes to do, I would invite each of you to consider what in that changes current law, because current law already prohibits and provides for an enhanced penalty for persons who have previously been convicted of a predicate forcible felony, which under Georgia law is a defined term. In fact, in the agenda attachment materials that I asked Ms. Park to prepare for you, current Georgia Code section 16-1-3 paragraph 6 defines the crime of forcible felony as any felony which involves an act of violence against the person of another. Family violence, or in this case, domestic violence, is a prerequisite of a violent act. A felony family violence or a family domestic violence, as it's termed, that's already a felony that involves an act of violence. Thus, it's a forcible felony. The amendment might look good, but it doesn't really change anything. If a prosecutor was asked to bring a prosecution against a criminal defendant who is alleged to be in possession of a firearm by a convicted felon, if that prosecution is successful, then at that point, should this measure become law in its current rendition, the judge would have two categories of punishment if the felony was a nonviolent felony or if the felony was a forcible felony, and now if the felony was a previous family violence felony, which is already a forcible felony. So because of the conflated definition of what constitutes a domestic violence versus a family violence, because family violence is also a defined term under 1913-1, the domestic violence definition is different. That conflates the definitions. It's already a forcible felony anyway, and because of the amendment that was tacked on at the behest of the prosecutors in Senator Anderson's bill that we discussed last time, that was actually on the floor today, that put the renditions to 1710-7 and 1611-131 as considerations for retroactive first offender status. Until we can see how that plays out, any amendments to this code section to do a nothing burger that's already covered under current law that doesn't need an amendment because it would be a forcible felony anyway, just seems to be unnecessarily duplicative, and it is on that basis that I would ask that this committee strike Section 3 from the bill in its entirety. A bigger conversation probably should be had about possession of a firearm by a convicted felon, because the felony version and the state version have multiple different places where they don't match, but doing anything here like this doesn't really change anything that's not already there.
All right, any questions for Mr. Weaver? Was it nothing burger? Was that
I didn't mean it to be ugly or rude. What I meant to say perhaps was just it's already a forcible felony anyway. It's a family violence or domestic violence. It involves a violent act. It doesn't change anything. It's already covered under current law.
I may start using that one myself. All right, thank you, Mr. Weaver. Next, we have Miss Maisie Lane Girton again. And I know we have 5 minutes for the next committee starts. I'm going to go ahead and let you speak. We're not going to rush you, and so we'll continue this hearing tomorrow at 4 o'clock, and we'll pick up where we left off, so I don't want you to be rushed, but I'll give you the floor.
Thank you, Chairman. That's really gracious. I'll go ahead and let you know that tomorrow I will be, we're fungible. It'll be Jill Travis here tomorrow, not me, but thank you for that accommodation. So I'll jump right in to Section 2. I can't speak directly to Senator Albers or Chairman Albers' concerns about how the admission into accountability courts is happening across our state. I can say, though, that judges are uniquely situated to determine what's going on in a person's life when they are facing criminal charges and whether or not the underlying concerns could be drug or alcohol addiction related, and even though the offense that they're charged with may not be, for instance, possession of drugs. There are other types of crimes that we especially see it in theft that are related to drug dependency. And so it's not uncommon, in my experience, for someone to enter into, for instance, a drug accountability court, even if they don't have a drug offense listed in their indictment. One question I guess we have as a membership about this code section actually involves some language that's already in the current code at lines 47 and again at 53 and 59. The code talks about the, quote, quality and expertise of the judges, and that would be something that would have to be reported on to the folks outlined in this bill. And it just seems potentially broad and vague to us. We're just curious what that would require. In section 3, at line 77, we just are uncertain exactly what it means that a person would be similarly situated to a spouse, parent, or guardian of the victim. We'll just raise that for your consideration as potentially vague and not really putting someone on notice about who the potential victims are under this new domestic violence felony concept. Generally speaking, across the board, my organization is going to ask you to refrain from expanding the sentences that require mandatory minimum incarceration. I won't repeat all that Senator Calzert mentioned earlier, but criminal justice reform was a place where we looked at data, and the evidence shows that mandatory sentences, they're not a deterrent, and what they are doing is filling our prisons, and it's expensive, frankly. So again, taking this kind of discretion away from the court that's best situated to make an assessment of whether someone needs to serve their entire term or not is something that we are going to routinely oppose and ask that you resist as well. For us, the next point of concern would be in section 5. So this is the section that expands venue for gang activity. And we understand that there are situations in our code already where this is true as well. For instance, in RICO prosecutions, there is an expanded venue option in kidnapping. As you can imagine, there's a transportation aspect to kidnapping. But what these types of venue provisions do is allow for and potentially promote forum shopping. And that is something that we typically, as a bench and bar, want to resist and not encourage. So to the extent that that is a concern to you, it is a concern to us as well. Section 6, again, for us, it's the mandatory minimum aspect of the sentence scheme that's suggested here. You'll find that at lines 153 through 155, and again at 165 through 167. Same argument, same concerns. I'd like to dig a little deeper into lines 184 through 186, which is the plain error section that the chairman asked about. So I guess I would back up and want to say, just kind of explain, plain error is when we have situations in a trial where something illegal happens, something that's contrary to the law happens, and kind of everyone should have known it, but no one makes an objection to it. This provision, as it's written here, would prevent our appellate courts from remedying it. I mean, this set of 184 through 186 basically would take us back in our criminal procedure to our pre-2013 evidence code revision. This is not helpful, I don't think, really to the administration of justice. I'm not certain, based on the conversation that happened earlier, what the motivation is for including it, but it does limit the ability for the appellate courts to correct errors at the trial court. And it's a pretty, I think the characterization of this section was that this is an opportunity for pretrial resolution, but this section, these lines, 184 through 186, have nothing to do with pretrial resolution, and in fact, I think are, a detriment to the way that our criminal cases, and frankly, civil cases, if I'm reading it correctly, it's not limited how plain error would be handled in our courts.
We have about 2 minutes before we need to be out of the room.
Okay.
Again, I'm gonna give you a chance to speak
Do you
again,
want me
but
to
I'll
just
let
wait
you.
until tomorrow?
If
for
you,
the
I
rest?
don't wanna rush you,
Happy
and
to
this,
do
I know
that.
it's a big
Yep.
bill, and so it's not fair to you. So if you wanna hold there, we
Yep.
can reconvene
That's right.
tomorrow at 4 o'clock. And so, thank you. With that, we'll be adjourned, and this bill will be on the agenda for tomorrow at 4 o'clock. Thank you.